Imagine you found your dream home in a posh village cash in hand, ready to move in only to have it all unravel at the last second because of one document. I'm Mikey, your enchanting barrister, and I'll be your guide through today's legal labyrinth. Joining us again is the man who makes the complex clear and the intimidating accessible. Your host for this session is attorney JFM, your dedicated legal voice for making the law simple and justice accessible.
Thanks, Mikey. I'm attorney JFM, thrilled to join you as your dedicated legal voice. Today, we're unpacking a real case where a high-stakes real estate deal fell apart and what it teaches us about contracts, trust, and why the small print always matters.
This episode promises a juicy story of a buyer and seller locked in a courtroom standoff, the dangers of assuming the paperwork is just a formality, and the difference between almost and actually closing a deal.
We'll break it down beat by beat. What went wrong with the earnest money? Why a single phrase in the contract mattered so much? The key legal lesson on contract to sell versus contract of sale. And how you can avoid being on the losing end of your own property dream.
So, Addie, JFM, let's set the stage. Mrs. V wanted to sell her house for a cool 10.8 million pesos, and Mr. C came ready with 100,000 pesos as earnest money. Sounds like a match made in real estate heaven.
At first glance, yes. They signed a simple receipt, pay the rest by July 15, or forfeit the 100,000 pesos, with one key condition: the deal only pushes through if all papers are in proper order.
Seems straightforward, but then things spiraled. Mr. C lost a check, called his bank to stop the payment, and changed his mind more than once. What was going on here?
It all came to a head when Mr. C showed up with a check for over 10 million pesos but refused to hand it over. He insisted the house title be registered in his name before he paid, and Mrs. V, completely frustrated, tore up the deed of sale on the spot.
Honestly, if I were forking out 10 million pesos, I'd want some assurance too. Isn't Mr. C just being a prudent buyer here? What if the seller vanished with the money?
That's a valid concern, Mikey, and a common one. But here's where legal terms matter a lot. Their agreement was a contract to sell, not a contract of sale. That difference turned everything upside down.
But aren't those just lawyerly words? Does a single word really change the whole equation?
It does. Think of it this way. A contract of sale is like walking across a finished bridge. Ownership transfers right after signing. A contract to sell is more like a bridge still under construction. Until the buyer pays every cent, the seller keeps ownership. Mr. C had no legal right to demand the title before full payment.
So, about that mysterious phrase, all papers in proper order, Mr. C argued the deal wasn't ready since taxes weren't fully settled. Wasn't that a good reason to hold back payment?
That was his main argument, but the Supreme Court said otherwise. In Philippine real estate practices, proper order simply means the seller must have the title, the signed deed, and the tax declarations ready to hand over, not the new title in the buyer's name.
So the seller doesn't have to process the new title for the buyer? That's on the buyer after the sale?
Exactly. Ownership is transferred by the notarized deed, the public instrument. Securing the new title is the buyer's responsibility. Mrs. V even offered to put the funds in escrow, but Mr. Buyer's escrow. C skipped that step and went straight to court.
So, attorney, what was the final ruling? Did the Supreme Court side with Mr. C or Mrs. V? I'm excited to know.
Well, Mikey, in the end, Mrs. V prevailed. The court said Mr. C defaulted because he didn't pay on time. He lost his right to the house and his 100,000 pesos earnest money. It's a painful example of how missing a deadline can cost more than the deal itself.
So, attorney, the big takeaway here is know your contract and don't assume you can change terms at the last minute. Mr. C's attempt to play lawyer backfired dramatically.
That's right. If you're buying, stick to what's written. If you're selling, you don't give up your title until there's cash on the table. The law tries to protect both sides, but only if you play by the rules you agreed on. If you want to change something in the contract, it should be mutual, meaning both parties must agree.
What a ride! We learned that in a contract to sell, no pay, no title is the rule. Earnest money is a real commitment, and proper order follows legal custom, not just your gut feeling.
That is right, Mikey. Take these lessons to heart. First, always know exactly what you're signing. Second, don't try to outsmart the process. Work with a lawyer when making life-changing deals. Third, respect the deadlines and conditions in your contract to avoid devastating losses.
For anyone planning to buy or sell property, your next step, consult a professional before you sit down at the closing table. It's far cheaper than learning the hard way, like Mr. C did.
Thanks for joining us today. If this episode opened your eyes or helped you feel more in control of your legal journey, don't forget to like, share, and subscribe. Every question you ask helps us make the law a little less mysterious for everyone.
Share your own contract stories in the comments. We want to hear if you've ever faced a similar real estate puzzle.
And remember, our discussion is for general information only, not legal advice. Always talk to a professional for your situation. I'm Attorney JFM. With me is our enchanting barrister, Mikey, urging you to stay informed and safe until our next podcast case file.